I'm pleased to make this presentation. First, I'm probably one of the early members of MDG Premium, and I've been happy to be involved with this. And this is really a good melding of our two groups here, because I'm also a member of US Inventor. And I'm a member of both because both organizations are important for my business and for my future. And that's why I thought it was so great to be able to make this presentation here. And I think everybody that's on this group and listening to this webinar should really pay attention to what's going on, because it affects our industry and my personal future and your future going forward. And that's why you really got to know about this situation.
And so yet you continue to plan your vacations on top of our annual meeting.
Okay. So it is a patent trial and appeals. Everybody calls it the PTAB, and it is a problem. I have a brief presentation, but then I really want to turn it over to Randy Landrino. He's the president of US Inventor, and he'll give you all the details of the horrors that we've been facing. So just a little background, ADMtronics, we do contract electronic medical device design, development, regulatory, and manufacturing of therapeutic and diagnostic electronic medical devices, but primarily in the therapeutic field. So we help physicians, inventors, and so forth bring their products into fruition. And I just want you to, this is my last slide, but just to let you know, on the engineering development side, we actually have a trademark that we call inspiration, innovation, and invention. That's our registered trademark for engineering services. And that's because over the past couple of years, we've secured 31 issued patents for our customers, and we have dozens of other provisional patents that we filed that hopefully will turn into non-provisional patents. And our clients, our customers come to us because they want to develop a product that then they will own and be able to take forward and either sell or get the benefit of profit from. And that's why when I learned about what was happening at the PTAB, I saw that this was a direct attack on small companies, small inventors, and especially in the medical device field, where there is the potential for one of our products to be acquired by one of the major companies like Medtronic and so forth, because you could develop a product and then have the benefit of selling it off to a major company like that. And I think when you understand what goes on with a major company like that, because of what the PTAB has given to them, it's important. Now, I know some of you may be involved with big companies, and that's fine. But for those of you that are developing a medical device that has the potential for growth in the medical device industry, this is a critical situation that you got to listen to and become involved with. And that's why, although none of my patents have been before the PTAB, when I heard the stories of what went on, I got actively involved with US Inventor and fully support them. I'm a member, and I've contributed and donated towards their mission. And Randy and the team has done a great job of elevating this issue tremendously in the face of Congress, which is so important to us. So at this point, I'm going to turn it over to the person that has all the details and can give us all the background on all of the effort that's going on. So Randy, you're up.
All right. Well, thank you. And Andre, thank you for getting me here. Andre was the one who made our issue, told Joe about it and invited me here. So am I able to share my screen?
You are.
Okay, so I'm going to hit, let's see here. Oh, what happened? I had to share screen down there thing, and I now don't see it.
Lower your cursor to the bottom.
Yeah, okay. Try this again. So you don't see my screen now, right?
No, let's give it another try.
Okay, here we go. Okay, now I see it. Share screen, good. And okay, here we go. All right, so what has happened to, you guys can see my screen, right?
Yes.
Okay, so what has happened to patent rights? And that's me, Randy Landrino. And I think I hit tab, do I? Do I hit down?
Power down should work. There
okay. So just quickly, a little bit of history. We kind of take a lot of things for granted that we have here in America. But at the time that our country began, the world was run by aristocracies. And if you were the friend of a king, he might grant you the exclusive right to do something like run a port or something. And by the way, that was called a patent. How about that? But this concept of you, whoever you are, from any walk of life, coming up with something, inventing something, and having ownership rights to what you just invented and came up with out of your mind, that was unheard of. And it was revolutionary in America for the common person, for anybody. And our founders were so brilliant in deciding to do that. And that was a totally revolutionary change that the aristocrats in the world just scoffed at it, like, oh, America, what are these guys doing? Like the common person, like they're going to come up with anything valuable, right? But soon, very soon, they weren't scoffing anymore because America was leading the way and out innovating all of them and becoming stronger economically as well. So our U.S. Constitution, Article 1, Section 8, Clause 8, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is directly in the Constitution. And here's something that many of your members probably don't know. The word right, as in someone's right to something, doesn't exist anywhere else in the Constitution except right here with respect to inventors and authors. The Bill of Rights came later. How about that? So we're talking about a hugely constitutional issue that if you invent and patent something, you should have the exclusive right to it. You have intellectual property rights to it. And by the way, intellectual property simply because it came from your mind originally. Patent Act of 1790. Oh, go back up. Oh, here we go. Patent Act of 1790, the third ever act of Congress under George Washington. How about this? Inventors were described as he, she, or they. Way back then, over 200 years ago, women who didn't have many rights otherwise were given all the rights of men when it came to patents and copyright. So for me,
back then.
Yeah.
Well, I don't think they meant they like it's meant nowadays. But
Fair
I think
enough,
they
but
was
I mean, under the law.
Good point. But the point is, yeah, so he, she, or they. In other words, they don't have to be a he or a she. but the point is, though, that was, they, I think they meant more than one inventor. But the point is, women had these rights too. It was seen as so important to this country that they went against a lot of norms of the time.
That's fantastic.
And by the way, the first Black owner of a patent, of course, slavery was a terrible part of our history. And, I guess a slave couldn't have a patent, but the first Black owner of a patent was Thomas Jennings in 1821, well before the Civil War. He was a free man in New York who actually invented the first version of dry cleaning.
Huh.
And he was a tailor, and he did quite well with what he invented for dry cleaning. And he used his wealth to help get relatives out of slavery and to help the abolitionist movement. So yes, this was for everybody.
However, that he was ever, I can't imagine that he was ever involved in a lawsuit one way or the other.
I don't know. I should look. Well, here's the thing. Back then, patents were assumed to have a certain value. It's like patents had a certain value until suddenly, they didn't. And now it's very questionable in many cases. But yeah, I should look into that. I don't know. All I do know though is that he invented it. He did well with it, and he actually did good things with it. So
I'm personally curious. If you revert on that, I'd be grateful.
Really, that would be a good thing to find out. So anyway, the point is, in our history, this whole idea of the incentive to invent something really valuable, which not only solves a problem that needs to be solved, the more valuable it is, typically the bigger the problem it solves, but also allows you to do something to become very successful, to employ people. It's good for the economy. It's good all the way around. And of course, when it comes to national security, when you are out innovating your adversaries, you stay ahead of them, and especially in areas of national security, weaponry, et cetera. And very important that we stay, and we kind of take for granted how economically successful we were because of all of the innovation, but also how secure we were because of all the innovation. And it's been a really key part of our country. So what happened? Well, efforts to weaken patent rights started around 1850. So in other words, this isn't just a brand new thing. A woman named Zarina Khan has done a lot of research on this, written a number of very big papers. And what she found is that new technologies would always create new industries. Existing entities would infringe patents and get sued, especially in the early years. And then they would try to get lawmakers who they had influence over because they were big companies. They try to get them to change the laws. And this started as far back as 1850. And we're talking with the telephone, with the telegraph and the telephone, locomotive, automobile, and all the way up to high tech now. Whatever the hot industry is where you had big companies trying to influence our lawmakers to weaken patent rights and patent laws. And our lawmakers held pretty firm until fairly recently. Not that there were no changes made, but they held pretty firm. And well, what happened recently? Well, a very bad law that Andre was referring to, he was referring to the Patent Trial and Appeal Board, but the law was the America Invents Act. A lot of people call it the AIA of 2011. One of the things it did was it created the Patent Trial and Appeal Board, which we call the PTAB. So realize that before this, any patent battle you had where you're trying to stop an infringer would take place in a real court. once you got past the point of if you had to sue him, it went to a real court. You had a lifetime appointed judge, which, by the way, that's more, if you haven't really thought about this issue, it's important to have a lifetime appointed judge. There you have a person who's not looking for a better job from someone like your infringer. And I'm not saying that, and the point is, a lifetime appointed judge is someone who can be independent. And I think in general, they're honest and decent folks. So prior to this bill, you had a real judge, you had a jury. Oh man, a jury is important in this kind of battle. You had a lot of due process. And you know what? It wasn't cheap. It wasn't cheap. But if you had a good case, you could do it on contingency, because most inventors don't have any money. Think about it. Steve Jobs didn't have any money when he started. Bill Gates didn't have any money when he started. Could they have done a big giant patent infringement suit? No, but not with their own money, but they could on contingency. So the attorney shares in the winnings, and you don't have to be rich to go
Randy,
to court.
do you
I know
have a
guy.
legal background at all?
Do I?
Yes.
No. Only.
I'd love for you to take yourself off mute, and Randy, if you don't mind, I'd love for you to interject here and there as Randy makes these claims, or not claims, but points of view. And I'd love to hear your point of view. Like, for example, when he said 1850 is when they took the first whack at the rights. Is that something you are aware of? You think of as 1850 as a date, or did you know the woman to whom he referred earlier? I'm just curious as he talks about these things from your vantage point, if these
A lot of people don't know about that. That's kind of anyway, but go ahead.
Any points first, Greg, before we continue? Anything?
Nothing, nothing right now. I mean, I think I've learned a little bit here this morning, certainly about the issue in 1850. I don't disagree. The idea of what kind of scope of rights we should grant to inventors has been a long-standing debate, and will continue to be. But some of what we've learned here, I've learned too, regarding the first inventor and first black.
Do you agree with the premise that PTAB equals bad for inventors?
Yeah, I would say I'd fall, generally in that category.
I mean, I'm going to give you more data, and Greg, you'll be able to
wait till you hear some of these. Wait till you hear some of these.
Yeah,
stories.
because see, here's the thing. Well, anyway, let me just kind of give you a little rundown here, and I'm open to any discussion here, and of course we're going to have time for questions and all that. So here's how it was sold to Congress, and I was back there fighting it, right? And the way it was sold, of course, think about this. You think big tech has a few lobbyists that work for them? We're talking like lots of lobbyists, and they're there all the time.
Yep.
And a lot of big companies have that, and of course, it's a problem with our lawmaking that
People love money.
Yeah, well, money talks too much in our governmental decisions, unfortunately. But here's how it was sold to Congress. The patent office isn't perfect. They're not perfect. They make mistakes every now and then. And when they make a mistake, there should be a cheaper, faster, more efficient way to handle it. It's got to be fair, and something cheaper and faster and more efficient than regular court. Because regular court is so expensive for one of these mistakes. And we're going to let the patent office do it. And this all sounds reasonable, right? The office is going to run experts. They granted the patent. They're the ones who should review it, right? That all sounds pretty good, right, Joe?
Reasonable to me.
Well, here's the problem. This is one of the big problems with laws. Man, you got to look at what are the potential unintended consequences? How can this be used? And what's really going to happen? And what's the worst case scenario of an outcome from the way a law is written? So here we go. Big tech, especially Google, they get this law passed. And the director of the patent office is going to be the one who actually sets up this new court, this new administrative court. Well, guess who Google? Well, I won't say Google got it because I can't prove it. But the next thing you know, the former head of patent strategy at Google is appointed as our director of the patent office. So a little bit of a conflict there, right? And so basically, Michelle Lee was her name. She was appointed as USPTO director, was the head of patent strategy at Google previously, and she's the one who set up this patent trial and appeal board. Now, Google, let me tell you something. Google is not, they do not want to empower a startup to compete with them. Now, I'm telling you, they do not. Here's something that you guys should know. Bill Gates was interviewed in 1998, back when they were the height of their power. They were huge, they were powerful, and he was asked, what is it that worries you the most in business? the interviewer thought he would say something like Oracle software or one of his competitors. He immediately said, somebody in a garage inventing something I haven't thought of. Because that is the threat. And it is the little guy that typically comes out with the game-changing invention, because the big corporation, they're not gonna work on something that could put existing product lines out of business, right? There's number one, they lose kind of this innovative spirit once they become huge and have vested interest, but they're also not going to put themselves out of business. Whereas some guy outside the box might come up with the next great thing that's really needed that would really impinge on these big guys. So anyway, Michelle Lee becomes the director, sets up the PTAB, sets the rules, hires the judges, and bottom line is it is a terrible situation. And there are a number of things wrong with it. One, no standing is required to try to invalidate someone's patent. Now think about this. Anybody, for whatever reason, can decide, well, I want to try to invalidate your patent, Joe. And now how could this be a problem? Well, how about if you sue Google for patent infringement and they win? Now maybe they win. I'm sorry, let's say they don't win. Let's say you win. Let's say someone else like Google that or anyone else that is associated with them, well, they could decide they're going to take you to the PTAB. Let's say you beat Google at the PTAB, but someone else wants to take you to the PTAB. You don't have to sue them. They don't have to be threatened. They can just try to invalidate your patent. And in many cases, you have multiple attacks, depending on how valuable the patent is. You can have multiple attacks at the PTAB to try to invalidate your patent. In some cases, it's been totally egregious. They're trying, it's not quite as bad as it was when it started, but I mean, there was one individual, the company was called Zond, Z-O-N-D. They had a technology for making, for providing what is it called? It's like a layer of metal with density at a micron level, right? Something that could not be done without what they invented. And they received like 100 attacks at the PTAB by people like, well, the technology was very important or looked very valuable to computer chip makers. So Intel attacked them numerous times. Amazingly, it was also something that razor blade companies could use. So Gillette also attacked them. But the point is, I mean, look, there's even been hedge fund guys who would find a drug company with a particular drug with a patent that's valuable to them, a publicly traded drug company, and they would short the stock, and then go through a public process of trying to invalidate the patent. And so the drug stock would go down, and the short guy shorting the stock would make money. In a case I heard of, and I can't verify this, but I think it's true, where a disgruntled ex-wife tried to invalidate her ex-husband's patents. I don't know if I can't guarantee that, but for a reason, they decided to say you don't have to have in a risk court, you have to have standing to sue somebody, to go after somebody, right? So it's a big problem. There's a lower level of evidence than a real court. In a real court, it's clear and convincing evidence. PTAB, it's a preponderance of the evidence. Again, you don't have a jury. You have very limited things like discovery. You don't have discovery like you have in a regular trial. And here's the thing. Think about this. By the way, there's an 84% kill rate. Now, what it means is, of the patents that get fully reviewed by the PTAB, 84% either get fully or partially invalidated. Now, when I say partially, and we got these numbers to back it up, out of about 3,000 patents, it's whatever 84% of the number is, that's the kill rate. And I can give you those numbers. The patent office, they quote numbers. The guys who love the PTAB say, no, it's not that low, it's not that high, and they have all these ways to quote that number. But from a rational standpoint, like for instance, there are things like, well, if this patent got attacked twice, and the first time it succeeded, it didn't get invalidated, but the second time it did, well, that's a 50% kill rate. Now, our viewpoint is, no, the patent is gone. It's 100% gone. That's 100%. But anyway, it's right. Here's the other thing too. Think about this. What about if you don't, by the way, the AIPLA, which is the patent law trade group, right? Greg, you probably remember that, right?
Yep.
Okay. AIPLA came out with a statement that a decent PTAB defense for a patent holder is $400. I think they said either $400,000 or $500,000 to $800,000 for a decent defense. So in other words, you're the inventor. To do a decent defense, it's going to cost you around $500,000. Well, guess what? It is an extremely rare attorney who'll do it on contingency. What if you don't have money? What if you don't have $500,000 in the bank? And the reason they won't do it on contingency except in rare cases, is because they so often lose. And number one, if you win it, you don't win any money. You don't get anything. You just don't keep your patent from being invalidated. And you could face multiple attacks at the PTAB before you could ever get to a real court where you might could win something if you have a patent left. So it's a pretty horrendous situation. So I know, Greg, you're probably, I don't know what you're thinking about this. Does this sound like too much, or do you feel like what I'm saying is?
No, I mean, yeah, there's I don't dispute the 85% kill rate. I mean, what you'll hear from my colleagues and probably people on both sides of the aisle, when you look at the statistics, you could go it on a patent basis or a claim by claim basis, and maybe there's some variance. I don't think the overall message is any different. The PTAB invalidates claims more often than they don't, and that I think is pretty clear. There's a few points here that are important and why I think it's so biased against inventors. The standing issue is really important. In district court cases, there has to be an actual dispute between the parties. The courts and the Supreme Court won't review any dispute if there isn't something that's right for litigation, between the parties. And it's a filter to make sure that actual real disputes about technology are getting to the court. That's the purpose of the standing requirement. And when you remove it, you leave it open to have multiple challenges that does stack things against the patent owners, whether you're an individual inventor or a large company. The other two things I'll say is just the lower evidence issue is another important one. I mean, we lawyers spend a lot of time thinking about, gosh, it would be nice to prove something by just preponderance of the evidence, or when we're looking at an invalidity defense in district courts, it's clear and convincing evidence. That's a really high standard, and it ought to be a really high standard because by law the patents are presumed valid. And so there's certainly things here when you take those two, the standing, the lower evidence, and how the PTAB is entitled to construe the patent claims in the process, really does stack things for the people filing these petitions, which are typically larger, larger companies. There are some legitimate disputes that go through there. The big companies like it because they can spend.
Oh, they love it. Yeah.
Well, from their perspective, and I do represent some large companies, and it is on one hand easier to invalidate a patent if you can spend $700,000 as opposed to $3 million in district court, and that cuts both ways in some respects. But I don't think what you're saying here is too much. I might debate a little bit about the 84% factor, but I think the premise behind it is.
Well, one thing, and I a lot of times I say this. A lot of times I say that when you look at the claims that, let's say you have a patent that doesn't get fully invalidated, so you still have a patent, but the key claims get invalidated. Well, you just have a piece of paper on the wall that has no value, right? Real value, except maybe to your mother. but so, and in fact, I'm going to have an example here that it's right in with your industry. That is one where he only got few claims invalidated, but they were the ones that mattered. So again, in his case, it might as well be 100% for him, even though you could call it a 30%, right? But he has nothing, And anyway, but so by the way, one other thing too, I thought of a few things as I was doing this that I didn't include here. One of the things that's kind of crazy is the PTAB judges. So basically, what you have at the PTAB is typically you'll have 3 of these PTAB judges, and they'll hear the case, and they're the ones that make the decision. The PTAB judges do not have ethics requirements like regular judges do. There have been numerous cases where there were PTAB judges who had conflicts of interest that would just shock you. There was a guy named, oh God, I can't remember his name now. Clemens, Matt Clemens. It's either Clemens or Clements. He was an attorney who defended Apple against patent infringement cases or allegations. He later became a PTAB judge on 24 out of 25 cases where he was involved with a PTAB case involving Apple. Of course, Apple won. And we were in DC. One of my colleagues was there, at a PTAB trial of one of our members, and there was Matt Clemens on the other side now, again, with the PTAB working for Apple again. Let me tell you something, a real judge could never do that. And it's a terrible, it's just all wrong. What we want is for inventors and patent holders to have their day in a real court. By the way, Robert, you have your hand up?
So these like really egregious conflicts of interest. How with all the lawyers in the land can this happen?
You know, I don't know. I got to tell you what, there are a lot of lawyers who are up in arms about this, and we're involved with them, and they're involved with us, and look, we've sued the patent office, but the courts find we have no standing and all kinds of crap like that. You know, I will tell you at the end of this presentation what the solution is, which we are fighting and working toward every day, every hour of every day. But I hear you. I mean, look, even down to like a court of appeals ruled a couple of years ago that the PTAB judges were all appointed unconstitutionally. Boom. It ruled. They're all appointed unconstitutionally. I'm thinking, oh man, this is great. It's going to put an end to it. So it goes to the Supreme Court, and amazingly, what they come out with, and by the way, they were considered unconstitutional because a real judge has to be ratified by the Senate. And a real judge is considered an officer of the government, I think they call it. I think that's the term. Where now they have so much power that they have to be ratified. And these PTAB judges, it was determined, well, they have a shitload of power too. I'm sorry for my language here, guys. They have so much power that they're also officers of the government. Therefore, they should have to be ratified, but they're not. They're just picked. And of course, what the Supreme Court ruled is, well, we'll just say that the patent office director can overrule their findings. So that makes them not as powerful and not officers of the government. So therefore, they don't have to be appointed like a regular judge. So what that means is it's even more political. The director of the patent office has even that much more power. By the way, the director is appointed by the president. And who gets appointed? By the president, typically. It's who the big donors want. And who are the big donors? Well, it's big tech. I will tell you this, and it doesn't matter. Just for our issue, someone who does not have to depend on big tech to get elected and who actually helped us by appointing a pretty good director of the patent office is Donald Trump. He actually had an uncle who was a big inventor too. But anyone running for president who's closely connected to big tech will not help us. I can almost guarantee you. So anyway, I'm going to move to the next one. But again, real courts are pretty independent, and that's what we want. That's what we want. There are also a couple of bad Supreme Court decisions. eBay versus Merck Exchange, that was in 2006. What they ruled was that what the Supreme Court said was it's in the public interest for the infringer to continue using the patented technology, even though they lost the infringement case. Now, prior to this, you win your case, you could stop the infringer, it's called getting an injunction. Now you have to pass a public interest test to get injunctive relief. And if it's a little guy versus a huge corporation, it's really rare. It's tough. And so what's the problem there? Well, what if they've taken over the market and now you win your case, and you get a court-ordered royalty, like my friend Paul, my colleague Paul would say, an English major in a robe tells you what you get, right? Regardless of what it's really worth, right? So it's not like so you win your case, you're not going to get nothing. You're going to get some kind of royalty. But you know what? How are you going to compete with them if they've already taken the market and you can't stop them? How are you going to have the next great American startup? Well, very difficult. That's why we don't have that. The other thing too is, if they know that you're never going to be able to get injunctive relief, they're just that much more willing to just infringe. You know, if efficient infringement is a term you hear a lot, where it makes money to just infringe. And because what are the chances that the little guy can even take you to court? What are the chances that they're going to get through a PTAB and still have a patent? And then if they finally go to court and somehow win, if they can't stop you and you're just going to have to pay a court-ordered royalty, why don't just steal everything from the start? And I know this sounds terrible, but that's the viewpoint of some of these corporations. And of course, unfortunately, it's a growing viewpoint. Another bad Supreme Court decision was the Alice decision. It was Alice versus CLS Bank. Here, the court. So let me just say something. Prior to this, what was patentable was really wide open, subject to, is it novel? Is it useful? We're talking about for a utility patent, right? Is it novel? Is it useful? Does the patent describe it well enough? And is it non-obvious, right? In other words, would someone skilled in the art find it easy to come up with? Unfortunately, that's a very subjective concept. But when you get a patent, the patent office has said that that's all true. But the Supreme Court added to that, well, you can't, on top of that, you can't patent an abstract idea, but they didn't define what that means. And so now, and by the way, that's a matter of law, not a matter of fact. If it were a matter of fact, you'd have like a robust argument between experts on different sides arguing, is this an abstract idea or is it not? But it's a matter of law. It's generally more like a very sharp attorney for the infringer arguing to a judge who might not be sharp at all that this is an abstract idea, when in many cases you look at it and you say, how could they even think that? But and by the way, this most often deals with things like software related patents, which by the way, some of the most important technology in the world, artificial intelligence, quantum computing, has a serious software component, right? This is important stuff to have patents around and be able to have startups attracting money and all that stuff. If your patent can be invalidated, how do you get a startup going?
Randy, let me just interject that that's an area that we're working on in a number of cases because of software as a medical device. And you know what you've got is situations where there's a concern from investors and underwriters and so forth about investing in these software as a medical device because they're concerned about it being infringed. And as you say here, 65% success rate in infringing these software type patents.
Yeah, it's that 65, it might be 60, it's 60 or 65, but bottom line is it's another way for if you can get the patent granted, it makes it harder to get the patent granted, but once it's granted, then it's another way that they can attack it. And you know, our viewpoint is all of this is bad news. It goes against what the incentive to innovate that our system, you know, started with and worked so well for us. So here's some examples. A key one for you guys, especially, you know how it used to be to replace a heart valve, you had to do open heart surgery. You had to open the chest up. You had to stop the heart. They wouldn't even do it on you if you weren't in pretty good shape. But those who received it, I think about 20% of people getting the operation died from the surgery, right? It was a terrible type of situation. An inventor named Troy Norrit, Dr. Troy Norrit, he's a heart surgeon in Oklahoma. He's the guy that had this wild idea that there was a way that it could be done that was non-invasive. And he worked like a dog to develop and to come up with and actually patent what is now the standard method, where they don't cut your chest open, they don't stop your heart, they feed a valve up with a catheter up through an artery in your thigh and place it in your beating heart. And as far as I know, a lot of people just go home the next day, right? You're talking millions of lives saved. You're talking, and everybody thought he was crazy, especially other heart surgeons. They thought he was nuts when he was developing it. But yet, again, this is what you want inventors for. You want inventors to have wild ideas, and sometimes they actually work and they change the world. So he invents it. He gets it patented, and a startup is working with it. And the startup tells him, you know, we can't pay you any money because we're a startup, not any money. He kind of let it slide. And the next thing you know, Medtronic buys the startup for $750 million. So now he and his attorney are talking to Medtronic, and Medtronic is actually emailing him. You know, they have an email, you know, a paper trail where they're saying they're considering giving him $40 million, which in fact might be really low for because it's a multi-billion-dollar industry now. Yet they were talking about it, he probably would have accepted it. But that was at the time when that bill, the American Invents Act, was about to pass. Medtronic was apparently supportive of it. Next thing you know, the bill passes, and they use the PTAB to invalidate his patent. And they didn't invalidate all the claims, but they invalidated the claims that mattered. And so he's got nothing. Now he's a heart surgeon, so it's not like he's going broke, right? But it's so unfair, and it is so against what should have happened. He runs into doctors today who do the procedure, and he says, you know, I invented that, and they think he's crazy because nobody's ever heard of it.
Randy, what year did this happen?
I can find out, and I'll get that. I'll provide that to Andre. He can get that to you. I think it would have been around. You're talking about the invalidation of it?
Yeah.
It would have been around 2013, 2014, in that range.
Not ancient history.
The PTAB got really going. The law was passed in 2011, but I think the PTAB got going in about 2013, and this was an early case. So it's 2013, 2014. But the point is, here's the thing. Medtronic is one of these companies. Why pay 40 million for something that's worth a ton of money if you can just take it, you know? Look, and I don't want to, for whatever reason, huge companies, and I know some of you guys are working with huge companies, maybe some of you guys on the call are with huge companies. You could encourage your companies to reward the innovators who come out with something really valuable rather than trying to find how you don't have to, even if you can, right? So biometric sensing devices. The inventor is Dr. Stephen LaBeouf. The company is Valencell. They're in North Carolina. It used to be that you could have, let's say you had a guy in a coma, they could put a sensor on his chest, and you could look at his heart rate, but these sensors wouldn't work if someone was moving. If on an active body, they just didn't work. Dr. Stephen LaBeouf, he's not a medical doctor, he's got a PhD in I think electrical engineering. Really brilliant guy. He's the guy who invented and patented the solution for biometric devices that work on active bodies. And had a company, the company was very successful licensing the technology. They even have things like hearing devices. I think these hearing devices even check your blood pressure and stuff. Anyway, don't quote me on that, but I'm pretty sure I'm right about that. But anyway, at some point, years later, Apple comes out with a smartwatch, and they approach Dr. LaBeouf and Valencell, and they're getting all the information. They're looking like they're going to license it, but they don't license it. They just copy it. So now, by the way, here's an egregious example of some of what's wrong with this system. He sues them for patent infringement on 4 patents they're infringing. They don't just attack those 4 patents at the PTAB. They also drag 8 other patents that he happens to have into PTAB attacks. So now he's fighting, instead of fighting 4 efforts to invalidate 4 patents, he's fighting 12 of them at the same time. It is absolutely an effort of a bully to take out a little guy. It is so egregious. Now, in his case, his company was behind him. He had support, very sharp guy. He was able to get through it without being totally destroyed like most of us would have been. And he ended up licensing to Apple for way less than what he should have. So he's actually got his technology licensed to Apple for some amount of money, even though not what it should be. And of course, at some point you got to say, you just got to end the blood flow, the hemorrhaging, and give in to some degree. And of course he did. He didn't get destroyed. But Apple, let me tell you something. If Apple comes to you and wants to license your technology, oh man, I would say do everything you can to get agreements signed that will somehow force them, no matter what, even if I don't know what to tell you on that. I just know that they're one of the really bad players, and all of big tech, of course.
We are friendly with Dave Albert. He's come to our conference twice. I expect him again this coming year. He's the founder of AliveCore, and as you likely know, Randy, they're in major litigation with Apple.
Yes.
In fact, their case even found its way on the executive branch's desk this year.
You said his name is Dave Allen?
Dave Albert, A-L-B.
Albert. And what's the company?
AliveCore, A-L-I-V-E-C-O-R. And in the chat, I will put for everyone a link to the blog for 10X, and you'll see a recent presentation of his. There, so you get a chance to.
Yeah. Well, here's someone. Look, he. I don't know. I guess he's not on the call, but I guess he'd be saying, "Yeah, you're right."
Oh, believe me, he'd have more to say than that.
Yeah. Well, it's. Oh, I'm sorry. I think I took us out of. Hold on. Let me get back. Here we go.
You can see your screen and everything. We're all good.
Yeah, but so yeah, it's, and of course, unfortunately, these big corporations, they have all this political influence. And I'll tell you, I remember when Barack Obama was saying, back in 2011, we need to make our patent system, we need to harmonize our patent system with the rest of the world. I'm thinking, gee whiz, why do you harmonize downward? We got the best. Why harmonize? And of course, he had a lot of Google execs like in his among his employees, in his administration. And anyway, the point is, big corporations have too much power, and that's a problem.
Greg, do we get a quick amen out of you, or?
What was that, John?
Get a quick amen out of you that large corporations have a disproportionate amount of power.
No, I agree completely.
Yeah,
I mean, they can keep a lawsuit going well until you've run out of investor patience and funding.
Oh,
Right.
oh
Yeah,
gosh.
there's That's true for a lot of companies, certainly for big tech companies. You know, the scale and size of companies like Apple, you know, Facebook, Amazon, it's outsized. You know, there is a whole other market, middle market companies where, you know, it's not that easy. You know, if you're even at 500 million in sales, if you got small margins, spending $3 million a year on a patent infringement case is not an easy ask for any businessman, any business person to make, and certainly is not easy for, you know, independent inventors. So this is certainly an issue that is more apparent between a small inventor, early stage startups, and really mega companies. But there is this sort of this inner part of the market where the patent system isn't still working the way it ought to, you know, to help.
Eddie, you have something?
You were asking me?
No, Ed.
No, hi,
Oh, Ed.
hi, Randy. It's I'm Ed Capianca. I'm American, but I live in the UK. I've lived over here for a long time. My perspective on the US patent system is a little different because, and I'm not a patent lawyer. I don't have it, but I have some experience with patents. The US system, I would actually suggest to you, isn't necessarily the greatest because
That's the truth.
In part because the United States was founded by lawyers. You have to remember that point first. And it's been said to me, and you know, others might shout me down on this, but in the US, it was basically you throw the patent in, and then you find out whether the patent's worth anything once someone sues you. And when you have it defended in court is when you actually really know the value of your patent. So I am not familiar with this thing that you've been talking about, but it was, at least my understanding, that the US system didn't require nearly as much evidence as the European approach to patenting. Now, to get something patented in Europe, you actually have to go to the patent authority with a whole bunch of evidence as to why this thing is. You don't have to have actually made the device, but you have to actually show a lot more than you do in a US system.
Well, the thing is, I hear
Sorry,
you.
Ed, I gotta disagree with you, Ed. Sorry, because I've gotten
Okay.
patents in the US and in other countries as well. And the patents in the US, you know, you have to, you know, you really have to have a lot more proof than what's needed in the EU and in other places. So I don't think I agree with you, Ed. Sorry.
Okay, like I said, I've heard it the other direction.
But I want to throw
Okay.
something in as well. Here's the thing. When you look at systems, their system, our system, what is it that created the most innovation in the world and was the most successful in driving innovation and startups and all that? And I got to tell you, I don't see how you could say that Europe did a better job than America. Now, big companies in Europe who are being sued for patent infringement, they might, you know, the big companies are not the one, you know, they're always going to argue on their side, right? But I think, you know, our whole point is, hey, look, you invent this heart valve replacement that's saving millions of lives and it's a multi-billion-dollar industry. You should get something out of that. Same thing with the biometric sensing, Stephen LaBeouf. You know, these are things that are highly needed. The bottom, there was a guy named David Furry. This is getting away from medical devices, but I brought it up because it's just an important example. He invents a camera. See, with pipelines and with like oil derricks and oil refineries, there are gas leaks that are very toxic with things like ethylene in them that you can't see with the naked eye. And they had a technology called a sniffer that was very inefficient, took forever, didn't work very well. And he invents a particular type of camera. You look through this camera and the thing looks like black smoke. And without the camera, you can't see it. You can go up, you can fly a helicopter along the pipeline and spot the leaks and fix them. He got the biggest award they offer from the Texas EPA. They said his invention lowered the level of ethylene, which causes cancer, lowered the level of ethylene in the air in Houston by 60%. A guy should get rich off of this, right? Or at least have something. A big company that was going to license it, they took it, they PTAB'd him, they invalidated the patent, and boom, it's got nothing. And by the way, all you guys might be thinking, well, wait a minute, they must be invalidating on something. There must be some legitimate reason that they're invalidating, right? And let me tell you, most often, look, if they were finding some unknown prior art that everybody missed that was significant, everybody missed it, the inventor missed it, his attorney missed it, patent office missed it, and it shows the invention, we wouldn't be arguing if they were finding actually patents that should not have been issued because it was already done before. What they most often do is they look at the same prior art, and sometimes additional similar, substantially similar prior art. And they say, well, we think it's obvious, because obviousness is a subjective thing. Patent office said it was non-obvious, but you know what? We think if you add this, and that's the other thing too, they add a whole bunch of different things together. This, multiple items, which nobody would ever have done, and they didn't do because no one did it till the inventor did it. In many cases, everything was known for decades, yet the inventor suddenly comes up with the thing that is so valuable, and they say, well, we think it's obvious, and there goes your patent. And by the way, so it's actually horrendous. There's a guy, just talking about inventions you guys might know about. If you have kids, anybody, you guys are aware of the this toy that allows you to fill like 40 water balloons at a time? Some of you, I'm sure you have kids. It's basically, used to make water balloons one at a time, took forever. Josh Malone, who's a key part of our group, he has 8 kids and has to come up with a solution because it takes hours to make the water balloons for these kids, right? So he came out with a bunch of balloons and he put it on Kickstarter. It went viral like you wouldn't believe. But a big player in the toy industry, Telebrands, they're based in New Jersey. They're the biggest as seen on TV company. They buy one of his from his Kickstarter. They shoot a commercial with it and flood the market with his product without talking to him. He ends up going to court, and he gets them into a real court before they get him into the PTAB. In a real court, he goes for a temporary injunction. They argue that they're not infringing because the patent doesn't describe the invention well enough. Patent says the invention, when the balloons are substantially filled with water, you shake the device and the balloons fall off sealed. Well, what does substantially filled with water mean? We don't understand this term. It's unclear. Right? The judge didn't go with it. Josh won, but then they appealed it. The appeals court laughed at their attorney for making that argument, and their attorney ended up getting sanctioned for making frivolous arguments. But then they take him to the PTAB, and the PTAB says, you're right. That's an unclear term. What does substantially filled with water mean? And they invalidated the damn patent. Now, and for any of you attorneys, think about this. So you can actually get validated in an actual court and invalidated in the PTAB. And of course, by the way, for any of you guys out there, luckily Josh wasn't a typical inventor with just one patent. He had filed a number of continuation patents, so he ended up with about 5 patents. So he wasn't out of the game because he lost his patent, because he had others he could fight with. But bottom line with Josh, now we're talking about with a toy. We're not talking about high tech and fighting Apple. We're talking about with a toy. He and his investors spent $20 million over 5 years, and they could have lost everything. In the end, Telebrands decided they had to get out because they weren't going to win it, or it was costing too much or whatever. Luckily, they were $1 billion company instead of $1 trillion company, and he got a pretty good settlement, and they're out. But I tell you what, most inventors could never have weathered that storm. And so the point is, real courts work. And people say, well, juries don't know enough. You know what? Juries know enough. It's a fair system, and PTAB is not. And by the way, there are all these efforts to improve it. Oh, we can make it fair. We can make the levels of evidence. We can do this and that, and whatever. And our viewpoint is maybe. But here's the thing. As long as it's run by the director of the patent office, who is appointed by the president based on typically who wants, like even now, and we think it will never be able. We want to get rid of it or be able to opt out of it. Why can't I opt for a regular court? Oh, but the PTAB's cheaper. Great, I'll take the expensive options.
Hey,
by the way, Robert, I see you had your.
Randy,
Yep, go ahead.
things I want to say. One is, of course, thank you. We're at the top of the hour. Some people will drop off. We're recording, so they can see the rest later. Does PTAB get to? Are they on top of all of these settlements and decisions before it? They get to overrule anything? That's what it sounded like from your last example with the toy. They change the rules. They say, no, we don't think so, and then everything else. Well,
typically, now I don't know Josh's example where he was validated. Well, I take it back. There have been a number of cases where patent was validated in a regular court and then went to the PTAB and was invalidated. So for whatever reason, and a lot of attorneys will say, how the hell could that happen? An administrative court can overrule actual court, an Article 3 court? I guess the way they wrote the law, it can.
Well, Joe, that's the point, is that if a big company loses in a court case, they revert to PTAB because they know they're going to do better there.
Gregory, what's the deal here? You're on mute.
Every day. The PTAB can hear these petitions, as we've described, directly, from anybody that wishes to file it. The PTAB also reviews decisions from typical patent examiners if you're appealing an adverse decision. And once those decisions are then appealable to the Federal Circuit Court of Appeals. And
Oh,
then,
well,
you know,
you're talking about if you're trying to get a patent issued and the examiner won't
well,
issue
yeah,
it.
both. The PTAB does both.
There's another side
I
to the
mean,
PTAB where you can actually
yeah.
use the PTAB to try to get your patent issued. But by the way,
But
if you get your patent
the
issued using the PTAB, that
is
doesn't
subject
inoculate you.
to judicial review.
I'm
Wait,
sorry,
what's that?
Randy, let me put you on hold.
Oh,
Say, Gregory.
one of the questions in there was that the PTAB is subject to some sort of judicial review.
Well, yeah,
it's
that's
limited
true.
by
In fact,
statute and some other issues.
In fact, yeah. So if you lose your PTAB case, you can appeal it, and the appeals court is a court of appeals of the Federal Circuit, CAFC, in Washington D.C. And unfortunately, you know, I'm not nearly as knowledgeable on some of this as I should be, but there's a what do they call it? Chevron deference. There's this tendency to defer to the public agency, and very often the appeals court. Oh, the most egregious thing is they will look at your appeal, and you do all your work to appeal it, and you have your positive. We're going to win this thing because the PTAB got it wrong. And next thing you know, very often you get what's called a Rule 36. The Rule 36 is you get one line that says affirmed, where they're basically affirming the PTAB's decision, and you don't get any discussion of why they agree with it and why they don't agree with your appeal or what you argue. It's so horrendous. And
Well,
anyway,
yeah, and that's true for all agency decisions. There is a lot of deference given to executive agencies under our system.
Yeah,
and there's some pullback on that, but
yeah, so
as long as the PTAB can say there's substantial evidence, the courts will effectively rubber stamp it. It really has to be an egregious error, and that does happen about 16% of the times, but not much.
well, we
I'm
want
trying to jump in.
Pardon me, my takeaway from this conversation is, that's funny. Ed just took the words out of my mouth. He wrote, I'm hearing a lot of PTAB bad. So what can be done? Now, I know you have 50,000 people behind you and there's letter writing and the like. And I'm thinking that what I'm hearing is underdogs get screwed. The big guy, you know, we need to fight the man, which is a theme in movies and literature and culture throughout generations and generations. And Eddie says, so what can be done? And we say, well, we've got a letter writing campaign, and
Well, it's way more than that. Way
and
more than
they
that.
have billions against
Yeah.
you. What can we, besides joining your organization, getting emails saying, count me on for that petition, what practically can be done here?
Okay, so here's the thing. There are some things that are helping us. And we've been fighting this for a few years now, but there are things that are helping immensely. For one, there's a growing awareness that China is becoming a serious threat, and they're seriously looking at, like, they're going to be the leader in key future technologies, which is very dangerous for our country. In fact, through all of our, we're actually in Washington, D.C. as we speak. We go to all these offices. We're a 501c4 corporation. We've had over 300 meetings in the House and the Senate this year. We bring inventors to D.C. to tell their stories. We can go to town halls. We'll let you know when you have a town hall in your area, so you can say, hey, I'm a voter for you, and this is important. Do you know what's happened to the rights of inventors? And I'd like you to meet. I'd like to have a meeting with you along with a key executive of U.S. Inventor. We protest where we need. In fact, look, you guys, I know people are funny about protesting, but we did a protest after Michelle Lee resigned from Google, right? Before Trump appointed a new director, and the person that was going to be appointed was absolutely the wrong guy, who now is a witness in hearings for big tech. He was going to be the director. We did a protest at the patent office where a bunch of us burned our patents, and it got attention, and it got the administration's attention. And next thing you know, Trump appoints someone good. Of course, now Biden has appointed someone who's not so good. Well, we'll see. We don't know if she's not good, but she's definitely 85% of her work prior to being appointed was big tech. We do FOIA requests. We've proven that the PTAB judges make more when they invalidate patents by bonus. By the way, letter writing, let me tell you something. Calls to your U.S. reps and senators are way more important than letters or emails. Absolutely. They get a handful of calls in a day, and that issue is known. They get a ton of emails, maybe. We get legislation.
They get a dozen calls, but they get $1 million contribution to their super PAC on the side.
Well, yeah. So obviously, what are we competing against? We're big money for sure, right? But here's the thing. Here's the thing. If for instance, there are 435 U.S. reps, 435 districts. Some of those districts are totally in the middle of big tech, like Nancy Pelosi's district. An awful lot of them don't have big tech as their biggest employer. We're not going to get if big tech's the biggest employer, we're not going to get that rep unless it's someone who doesn't care about being reelected. But there are enough of them who don't have that situation that we can get to them. And our issue communicates to anybody who cares about America and what matters to this country, especially where China's threatening and where big tech has no competition. I mean, the issue that, hey, startups need to have patent rights to compete with big tech, and that's why there aren't startups competing with big tech. These are issues that are becoming more and more known. And the there's actually now a new China Commission. It's called the Select China Committee in the House and the Senate. They're bringing up the issue of patent rights and what we've done to our patent system and how it's helping China get ahead of us. So this is a key thing that's happening now. So we're gaining steam. We don't have the money that the other guys do, but it's like, let me tell you something. When an inventor is in a congressman's office, it is way more powerful than when a lobbyist is. They know who's a hired gun and who's actually trying to do something right. Now, of course, you still have the money issue, and but I tell you what, we're making ground. And actually, last Congress, there was a bill. Thomas Massey from Kentucky is our champion in the House. He went to MIT. He has 29 patents. He had a startup based on his patents. Real sharp guy. He had a bill that will be reintroduced. It gets rid of the PTAB. It gets rid of those three big issues. It handles them all: the 2 Supreme Court decisions and the PTAB. It's an ambitious bill. We had about 26 co-sponsors on it last Congress. So it's going to be reintroduced. We're going to push it hard. And there are actually a couple of bills right now that we're looking at that there are serious issues with them that we're not sure whether or not we're going to support them, or we're trying to get them changed to be good enough. But the point is, this isn't just some small effort. Let me tell you something. Early in the year, we did a big protest because the person who was about to be appointed as the chair of the IP subcommittee, the intellectual property subcommittee, the key position in the Judiciary Committee on our issue, is a total enemy and has been helping big tech for about 15 years get everything they want passed.
I'm going to interrupt because Greg needs to head out. I want to ask you, Greg, and Randy. Yeah. Randy, have you attempted to enlist big law firms and law associations to help you with this? Second, Greg, I can't help but wonder if, I agree with him, and I mean, no disrespect, whether this happens or that happens, I get paid anyhow. So whatever, I'm just playing the game that's ahead of me. Or is there a point of view, like a sense of this is unjust and lawyers unite kind of thing, or we just get paid no matter what?
That's a good question. I mean, I make a living for sure by helping companies develop and implement a patent portfolio. And I can tell you in the last maybe 5 to 7 years, people are pausing a little bit more than they used to when we're thinking about IP. They're thinking about it more smartly. They're thinking about it in a more sophisticated way. For companies that are fortunate enough to have some VC funding, they're looking at it and say, look, I need to develop a portfolio that can position me in the best possible way. And the practical outcome of what we've learned about here is to do that, it generally requires even more upfront costs. One thing that Randy said, and I've mentioned in prior press, is an example just related to continuations. Keep a continuation alive forever for all of these reasons, because it's the only way that you can keep somebody on their toes if there's this pending right out here that you could use to address any issue that comes up in the PTAB. But that still is more expense up front to address, an issue. So to me, it's not so, one or the other. There is probably a division within the patent bar who tend to represent maybe some more startups and independent inventors that are up in arms for sure about the state of patent law.
One of the problems is that most attorneys who litigate, they might work with some small patent holders, but they also typically work with large patent holders, right? Big companies.
Right.
And big companies, and we've even had guys that say, I love what you're doing, but I can't be public on it because I'll lose clients. Right. And like among the AIPLA, why aren't they all up in arms? You know what? Because most of the members of the AIPLA working for the big guys, or at least have some of that as their work. And so it is an issue that it's hard for people to take a stand on. The attorneys who work entirely with the little guys, oh man, they're all on our side, big time. And it is egregious. I mean, I'm telling you, I know this sounds crazy, but you invent something truly valuable right now, and I'm telling you, the chances are you'll be crushed. Even if you're rich, even if you can afford $500,000 PTAB attacks multiple times, even if you can afford it, there are numerous guys who've lost all their money and their patents. I mean, it's just horrendous. It's all wrong. It's un-American, and you know, the only guys who really benefit from it, big tech, and big companies, of course, and the guys in the middle who have a lot of money and a lot of sophistication, and they don't just do a few patents, they do whole groups of patents, and they have lots of continuations, and they have enough money to fight a lot, and blah blah blah. They can survive, but the system
Randy.
wasn't supposed to be that.
Yeah, Robert, we're
Randy.
half past the.
I know, but you guys gotta like make room here.
Go ahead.
So we're all sufficiently now aware and alarmed by the situation. I've heard about it. When I started my journey, I got my 2 patents, and I looked at them, it's got Michelle Lee's name on it. So now that we're all alarmed here and we know about the problem, how do we protect ourselves? Now, I've heard about abatement insurance. Now, is that something that can mitigate the situation? I mean, abatement insurance?
I'm not sure. You talking about insurance against like some kind of litigation insurance?
Yeah, abatement insurance. So that, from what I understand, my patent attorney said that, when big tech comes after you with 30 lawyers, abatement insurance makes sure that you got 30 lawyers too to go up against them.
Before you answer, Randy, in the interest of time, I've shared your email address in the chat. It's RL for Randy, rlinventor@protonmail.com. And Robert, I encourage you to continue this conversation with him offline, because
let's do that. We'll do that, because I don't really know much about that. What I want to say to all your viewers and your membership, this is a very important cause. It's not just for your future, but it's for the whole country. Are we going to stay ahead of China? Are we going to have startups that compete with big tech? Are we going to continue to be the kind of country we were and were for so long? Are we going to continue to be different from the rest of the world? Right? This is one of the key points. I encourage you to go to usinventor.org, sign our inventor rights resolution. It'll keep you informed about what we're doing. You can participate in calls to action, help us get in front of your lawmakers. Look, you can set a meeting with your lawmaker more easily than I can, and especially in the local district, and donate to us. Your donation helps us fight. By the way, $100 donation gets you this really cool mug from US Inventor. Creative disruption is necessary for progress. And the other thing is, normally it'd be $250, but for $200, you'll get a mug and you'll get this endangered species. And it says up here, Homo sapiens inventoris. And anyway, this will be your thing. And by the way,
help today. And
made in America.
Andre, if you know other smart dudes and gals who want to present, any friend of yours, my friend, he is a friend of mine. I want to thank you, Randy, for today. Andre, of course, everyone for joining, and we'll see you this time next week.
Super.
Everyone,
Thank you.
Thank you.
And everybody, get in touch with me. Thanks.